When it comes to prosecuting cases, your office is about to go in front of the Supreme Court to argue in favor of a Maryland law that allows for the collection of DNA samples from people who have been arrested but not convicted of crimes. You say this tool is essential, and you're challenging the ruling from the Maryland Court of Appeals that found the law unconstitutional. Why?
Well, this is a huge issue, and it's going to be argued at 11 o'clock on Tuesday in front of the Supreme Court. All 50 states in the United States have joined with us as an amicus brief. Our Court of Appeals overturned the DNA collection statute here in Maryland. Every federal court in the United States that's looked at it has upheld it. Every other state court has upheld it except for Minnesota. So now we're in the situation where we're going to look at the whole notion of taking one's DNA and how it comports with privacy. And so in Maryland, what happens is the legislature passed a law that says if you have been arrested for a violent crime, and that means the police believe there's a probable cause to believe you've committed that crime, and then a judge also says there's probable cause to commit the crime, they can take a swab of your DNA, touch basically a Q-tip against the inside of your cheek for 1 second, and then test that. And they don't test it for genetic things. They test it only for identification. They put it into a computer anonymously, and if there's a connection, if there's a hit with DNA that was taken from a cold case, a rape case or murder case, something of that nature, then you can go get a warrant and you have reason to arrest that person. So this is how we are able to solve old cases, cold cases, violent cases. I personally tried a case involving a woman named Hollis Church who had been raped and brutalized and beaten in Kensington, Maryland. Every day thought about the case, never thought they'd find the guy who came into her house with a mask in the middle of the night and beat her. This guy, was in Virginia, where they basically take your DNA if you walk near a police department station, and they connected him up with this rape, and we were able to convict him and get a serial murderer off the streets. It's a technology that we have that the ACLU and other groups should be in front of, because DNA is race neutral and socioeconomically neutral. It's an anonymous putting of that into the computer.
Yeah, well, the ACLU and others say it goes beyond a fingerprint, but you've compared it to, because it goes into a person's very genetic makeup, and that having this very private information stored in a federal or state database leaves open the possibility that it will be used for other purposes.
It could. It's actually the exact same as a fingerprint, which we take it when people get arrested for shoplifting. But because there's never been an allegation, there's never been a suggestion anywhere in the United States that the police use this DNA for any other purpose than the loci, the 13 identification loci that's tested for. In fact, it's a criminal offense if they were to use it for any other purpose. So it's exactly the same as DNA, and so it's an identification of the person you have in front of you and whether or not they committed a previous crime.
I'm sure.
Supreme Court on Tuesday. Will you be there?
I will be there. My chief deputy, Catherine Winfrey, is going to be arguing. I argued the first case in front of Justice Sotomayor, and we won 9-0 in that case. I would expect us to win 9-0 in this case as well.